Ready? 3, 2, 1, start. Improvement Trust has filed this appeal challenging the judgments passed by the courts below, whereby the suit of the plaintiff for declaration and permanent injunction was decreed and the appeal filed by the appellant was dismissed. Stop para. The case of the plaintiff was that the Defendant Improvement Trust had proposed to acquire 55 acres of land for a development scheme. Stop. The plaintiff was owner in possession of some land acquired by the trust which was included in the said scheme. Stop. The plaintiff approached the trust for allotment of a plot for her rehabilitation as a local displaced person. Stop. In consequence thereto, plot number 153 measuring 6 marlas was allotted to the plaintiff wide resolution number 488 dated 6/3/1990. Stop. The plaintiff deposited rupees 3000 wide receipt dated 19/3/1990. Stop. The plaintiff received memo dated 19/3/1990 qua cancellation of the said allotment. Stop. Hence, suit for declaration challenging the cancellation of allotment of plot and permanent injunction was filed by the plaintiff. Stop para. Improvement Trust in its written statement admitted the factum of allotment of the plot to the plaintiff. Stop. It was averred that the allotment of the plot made in favor of the plaintiff was illegal as she could not be categorized as a local displaced person. Stop. The trial court wide judgment and decree dated 23/5/1990 decreed the suit of the plaintiff. Stop. Aggrieved by the said judgment and decree, defendant preferred an appeal and the same was dismissed by the district judge wide judgment and decree dated 1/9/1990. Stop. Hence the present appeal by the Defendant Improvement Trust. Stop para. The substantial question of law that arises for consideration in this case is as to whether the plaintiff could lay claim to the plot on the basis of provisional allotment which had never fructified into permanent allotment. Stop. The learned counsel for the appellant has submitted that the question of law involved in this case had arisen in a similar case. Stop. The present appeal at the time of admission was ordered to be heard with the said appeal. Stop. The learned counsel has placed reliance on the said decision in support of his case. Stop para. The learned counsel for the respondent, on the other hand, has submitted that the plaintiff was allotted the plot in question and in pursuance of the said allotment. Stop. The allotment could have been unilaterally cancelled by the trust. Stop para. After hearing the learned counsel for the parties and going through the record available on the file carefully, I am of the opinion that the instant appeal deserves to be allowed. Stop para. Thereafter, in the present case, an application was moved by the respondent that the appeal had been disposed of in her absence. Stop. Wide order dated 7/3/2007, judgment and decree dated 31/7/2001 were set aside and the appeal was restored to its original number. Stop para. In response to the argument raised by the learned counsel for the Improvement Trust that no opportunity of hearing was required to be given to the respondent before refusing to accord approval qua allotment of plot to the plaintiff by the trust, it was observed as under. Stop over.